Well, hello and welcome to the CBN News YouTube channel. My name is Dan Andros, and we're going live with you today. We got some breaking news. The Supreme Court just issued 3 rulings today. One of those was what some would say is a loss for the pro-life movement. And this was a case that was against the Food and Drug Administration brought by the Alliance for Hippocratic Medicine. And so the Supreme Court rejected this lawsuit that was challenging the FDA's approach to regulating the abortion pill mifepristone. And the ADF responded to this just moments ago. They said, "We're disappointed that the Supreme Court did not reach the merits of the FDA's lawless removal of common sense safety standards for abortion drugs. Nothing in today's decision challenges the fact that the FDA's own label says that roughly 1 in 25 women who take chemical abortion drugs will end up in the emergency room." And their statement goes on after that. And joining me now is Dean from Regent University, Brad Jacob, also a constitutional law expert. And just your reaction on this decision, what stuck out to you?
Well, Dan, this came down exactly the way I expected it to. Unfortunately, for the pro-life cause, the advocate who argued the case, Erin Howley, is, among other things, she's a senator's wife. She is an advocate for the Alliance Defending Freedom. She's also my colleague here on the Regent Law School faculty. We did a moot court preparing her for this case, and it became very clear as she argued and we questioned her. The whole issue here was going to be standing to sue. The court did not address the merits of the claim as to whether the FDA followed the right procedures in liberalizing the rules for mifepristone, the abortion-causing drug. They never got to that issue. They unanimously said that the plaintiffs who brought this suit did not have constitutional standing to sue, and therefore the suit could not be brought in federal court.
Yeah. Let's talk about that a little bit, Brad, because I think Justice Kavanaugh addressed this a little bit, and dive into about like the not having standing sort of in this particular case and how it applied. I mean, essentially Kavanaugh, and you can explain this better, but was saying, that, hey, you're trying to say that you don't have to do these. I have his exact quote here. So why don't you try to summarize what Kavanaugh said, and I'll read his exact quote here in just a second.
Okay, absolutely. This doctrine of standing to sue is one that a lot of non-lawyers may not be familiar with. But Article 3 of the Constitution that sets up the Supreme Court and the other federal courts says that to bring a case in any federal court, you have to have what's called a case or a controversy. And there's a specific list of the kinds of cases and controversies that can be brought in federal court. Since the very beginning, the Supreme Court has said that one element of a case or controversy is there have to be 2 parties on opposite sides who really have a stake in the case. The court does not give advisory opinions. They don't just hypothetically say, well, that would be unconstitutional. George Washington actually tried to get the Supreme Court to tell him whether a pending federal statute was constitutional. And all the way back then, the justices said, no, we can't make the best decision on an issue unless there is a real case with parties on both sides who've got skin in the game. They have something at stake, because then their lawyers will give us the best arguments and really tee up the issue as well as it can be, and then we can make decisions. So you've got to meet that test. And the court has said that standing, the ability to sue, to bring the lawsuit, has 3 components. The first is usually the biggie, and that is the plaintiff must have suffered some particular harm, some harm unique to that plaintiff and not just everybody in general. So that's really significant, because what it says is that even if the government has done something that is illegal or blatantly unconstitutional, you can't challenge it in court unless you can show that you as an individual or an organization have been specifically harmed. And so there are a lot of instances in our public life where the government may have acted wrongly and there's nobody to challenge it. There is simply no plaintiff with standing who can bring the lawsuit. And that is what the court found here, that issue of particularized harm was not met by these plaintiffs who were challenging the FDA's liberalization of mifepristone, even if they were right on the merits. Even if the FDA violated the law, the court says these people can't challenge it.
So are there any instances, Brad, where, because they kind of, and I'll read a summary here of kind of what Kavanaugh was saying. He rejected the challenger's contention that the FDA's relaxed regulation of the drug injures them because although they are not required to prescribe mifepristone themselves, they could be required to provide emergency treatment to women who had obtained the drug from other healthcare providers and then suffered complications. So I guess what you're saying is the harm is just too far removed, right? It's like a hypothetical harm that is coming down the road. I guess my question to you is going to be, are there past precedent here in the Supreme Court where a hypothetical harm, because that's essentially what they're arguing here, this is going to happen to me in the future, this harm. Has there been a case like that you can recall?
There have been a lot of cases in the Supreme Court and lower courts where there's a finding of no standing. Some of the case laws involve things like environmental regulation and people saying, well, you can't cut down the trees in this park because someday I might want to go hiking in that park, or some of these kind of things. The court and the lower courts have often found cases where there is no standing because it's too speculative. It might happen, but we don't actually know that it's going to happen. The plaintiffs here made three different arguments for standing that are a little bit different, and the court rejected all of them. The first one is the one that you brought up, which is they say mifepristone can cause complications. A woman could get like half aborted and have the thing go south, and she'd have to go to an emergency room, and we might be the doctor, and we might be forced to complete an abortion, which violates our conscience. And the court rejected that one by saying there's a federal statute that protects you. There's a federal law that says doctors cannot be forced to participate in an abortion if it violates their conscience. And so the court says you don't have to worry about that. If the woman does have a medical emergency, they would have to find another doctor to handle that. They can't force you, the pro-life doctor, to complete the abortion. Then there was a second argument that the doctor said, well, we might suffer economic harm down the road because some of these women, once their abortion is over, they might have complications to their reproductive systems because of the mifepristone, and they may come to us for care, and that may take up our time, and we might have to have more insurance, and there's financial costs that might come to us in the future because women use this drug. And the court rejected that one and just said that's too speculative. You just don't know that that's ever going to happen. Not any one of these doctors knows for sure that he or she will ever have any future costs based on a woman who had used the mifepristone drug. Then the third argument was, well, this Alliance for Hippocratic Medicine has standing representing the interests of pro-life doctors. And the court said, if the pro-life doctors don't have standing, then an organization of the pro-life doctors doesn't have standing. The associational standing would only flow out of actual standing by the members of the association. And since we have found that the doctors themselves don't have standing to bring this case, then the association doesn't either. So three different arguments, but in all of them, the court comes down as saying there isn't anyone here who we can know with confidence is actually being harmed by the FDA making mifepristone more easily available.
And Brad, you have a unanimous decision here, which doesn't, especially on a contentious issue like abortion, we don't always see. So what do you make of the fact that this was a unanimous decision?
Well, it's I think it's almost certain that the court was not unanimous on the substantive issue. Did the FDA follow the legal rules to make mifepristone more easily available? I am quite certain the court was not unanimous on that, maybe 6-3, 5-4. But the Roberts Court has been very good. One of the real highlights of Chief Justice Roberts' tenure as chief is he has been very good at steering the court to trying to find non-controversial answers to controversial questions. And this is a very typical Roberts Court approach. They would never agree 9-0 on whether the drug's approval is proper, but they were able to agree 9-0 that these plaintiffs don't have standing. And by the chief being able to get the case into that posture that we are focusing on that standing issue, he's able to get all 9 of them to say, yeah, that's right. There's no standing here, regardless of whether we think the FDA has acted properly.
Yeah, it's interesting. So I know because this is in your area. I'm just kind of throwing this in for people to chew on. But the politics of it, you're going to see a lot of headlines like claiming victory on this. You know, that sort of vibe. You know, pro-lifers defeated. That sort of sentiment. But it just seems like this particular angle and approach didn't work out. It didn't necessarily put the drug on trial, or didn't, like you said, put the FDA on trial. They kind of didn't even get to that part of it. So that could be coming at a later time down the road. And I guess my question for you here on this, Brad, as the law expert here, might another group be presented in the future here on a similar case related to this drug that might have better standing?
You hate to say never. These things happen that are unexpected. At this point, I'm having trouble thinking of who would be a plaintiff who could win this suit. And frankly, the Alliance Defending Freedom, who were the lead attorneys here, they're smart lawyers. If they had somebody better to bring the suit, someone who was more likely to have standing in court, they probably would have done that. And it's a little bit hard to put your finger on who is specifically harmed. Babies who are aborted are harmed.
Right.
But,
yeah,
but
of course.
An unborn child is not going to be able to bring a lawsuit in federal court.
Right.
But of those of us who have already been born, who could challenge the use of this drug? Who is harmed? Well, no one's forcing women to use mifepristone. They choose to use it. They are pregnant. They want to have an abortion. They believe they should have an abortion. And so, if this group doesn't have standing, as the court has told us, I'm not sure who would. I don't know how anybody could say. I mean, I guess a woman could, if a woman used mifepristone and then changed her mind, could she argue, because this was so easily available, I didn't have to really wrestle with aborting my child? Maybe,
yeah, or possibly.
I doubt it.
I was kind of thinking the same thing, Brad. I mean, I think because remember one of their arguments, I know that the defense in the oral arguments brought a lot of facts about how safe and effective, mifepristone is. So without having to have a doctor prescribe this to you, perhaps they could say, if something did happen to someone, you hate that it would have to get to that point, right? That someone would take this drug and then they have a side effect and some horrible side effect. In addition to, as you said, the unborn baby, the pregnancy being terminated, then perhaps they could say, hey, you told me this was safe. And, maybe then they could revisit all these arguments and then this person would have been harmed from that. So that, again, this is all hypothetical and a potential, I guess, down the road.
Yeah. And it's because by definition, the women who are using this drug think it should be available. They want it to be used. It's a limited option, but there is that possibility, I think, that a woman could change her mind, could realize, wow, that was much more dangerous to me than I was led to believe. And the FDA allowed me to get it through telehealth. I didn't have to go to a doctor's office. And one of the rule changes was now a nurse practitioner can prescribe it rather than actually needing an MD to prescribe the drug. Well, of course, nurse practitioners prescribe lots of other drugs. My diabetes prescriptions all come from a nurse practitioner. I don't actually see a doctor for those. So in other areas of medicine, that's not uncommon, but you could at least potentially make the claim that this was more dangerous than the FDA led me to believe. And maybe that suit will come at some point. I don't know.
We'll see. I mean, Liberty Counsel founder and chairman Matt Staver said after this ruling, he said this case is far from over. The same lawsuit can be refiled with different plaintiffs who have standing. The FDA should no longer be allowed to circumvent safety laws to allow a eugenic drug to destroy innocent children and harm women. Chemical abortions are never safe and harm women and kill children. So there, Matt Staver promising at least that this is far from over. So we'll see what happens there. So obviously this ruling came down. This was a disappointment for the pro-life community, but we'll keep an eye on it, Brad, as this one comes forward. Are there any other areas of this case that kind of stood out to you? We talked a lot about standing. Is there anything else that you wanted to hit or cover before we move on and just quickly talk about the other cases that are yet to come?
Well, I mean, this really is a case about standing. It's a case about the reach of the federal courts. You've said it before, but it's important to remember this case is not saying anything one way or the other about the abortion drug or about the FDA's handling of the abortion drug. I have a hunch that if there were a plaintiff who had standing, that a majority of this court would have found that there was a problem with the way the FDA handled this, that they didn't follow the right procedures in liberalizing the laws around this drug. I have a hunch that would be the majority decision of the court, but we don't know that. We have not had any answer one way or another on what the court thinks about that. I also, as you know, as a firmly pro-life person, my wife and I have adopted 4 children out of crisis pregnancies. We're thoroughly committed to the pro-life cause. I'm always sad when the pro-life side loses in litigation. I think there are questions about how significant this is. Number one, as long as the FDA is under the control of an administration that is strongly pro-choice, even if they lost this case, it would probably only slow down the approval of the drug. They would have to go back and use the right processes, follow the Administrative Procedures Act and all that, but they might have gotten to the same rules anyway in the end. And one of the lessons that I, as a pro-lifer, pull from this is once these drugs are out there, even if the FDA didn't approve it, you could still buy it online from England or Canada or somewhere else. And it's going to be very hard legally to stop a woman from getting an abortion when she can do it in her own bathroom with a product that was delivered to her in the mail. I think the pro-life community has to really put a lot of our focus at this point on persuasion, on convincing pregnant women that we love them, we want to care for them, we want them to care for their children, we'll adopt if we need to, we'll help them financially. Law is not necessarily going to solve the abortion problem at this point.
Yeah, and God bless you, Brad, for adopting 4 kids. I didn't know that. That's awesome. You got a busy house over there, I assume.
Well, most of my kids are grown at this point.
Okay, all right.
Our 3 youngest were special needs adoptions, and one of them has passed away, but the other 2 are still with us, and they bring so much joy and delight into my life. But they were situations that the birth mother either couldn't or wouldn't raise them, and we have just been so blessed to be able to have them in our family.
Oh, that's excellent. I'm sorry to hear about your one child, of course. So, all right, we have a couple real quick, Brad, before we let you go here. We have a couple more decisions. They might come down tomorrow that we were looking at. Real quick, touch base on just what those are, and then we'll get ready to cover those when those decisions come down. The immunity case is one.
The immunity case is one, and the question is, can Donald Trump be held criminally liable for things that he did that, if they were in fact crimes, if he violated the law during the time that he was president of the United States? Or does he have immunity from everything that happened while he was president of the United States? So there's a couple of more extreme positions on this. One that's been raised by the president is the idea that from the day he takes the oath of office until the day he leaves office, nothing that he does may be criminally prosecuted, or at least may not be criminally prosecuted unless he was successfully impeached for it. I don't think the court's going to take that position. The other extreme would be to say you can criminally charge a president for anything that he does during his presidency. So if you can find some way of arguing that, the president declaring war or the president, taking some action could be argued as being criminal, he can be held liable for that. I don't think the court's going to take that position either. They're going to say there's a lot of executive judgment calls that a president gets to make, and you simply can't hold him either criminally or civilly liable for those things. I think the court's going to take a middle position and say that it depends on whether the crime was part of his actual duties as president, or whether it was essentially something that he did as a private citizen or as a presidential candidate while he was still president. I think that's where the court is going to come down on that one. We'll wait and see. But my guess is they're going to allow the possibility that the president could be convicted for, let's say, inciting the riot at the Capitol on January 6, 2021, because when he was doing that, he wasn't functioning as president. He was functioning as a person who was running for re-election. But that's the immunity case that's coming soon.
Right, and then the other case we had our eye on. There was one more.
There's another case, which is another abortion case coming out of Idaho, and Idaho has enacted a very strong pro-life statute that bans abortion in most circumstances. But there is a federal statute that was enacted a few years ago that is designed to make sure that people are not denied emergency room care because they can't pay. The whole purpose of the statute was, if you've been in an auto wreck and you're dying and you need to be operated on, and you need care in the emergency room, the hospital can't say, oh, you don't have enough money to pay us, so we won't treat you. We can't just let you bleed out because you can't pay. But the question here is, what if there's an argument that the life or the health of an individual, a woman, a mother, is at stake if she doesn't get an abortion? Does that federal statute overrule the state law against abortion? If the doctor believes this woman's health will be injured if she doesn't have an abortion, but that abortion is illegal under state law, does she get to have the abortion because it's that kind of emergency care under the federal statute? And that's an interesting question, because clearly Congress wasn't thinking about that.
Yeah.
When Congress enacted this, they were thinking about people who can't pay. They were not thinking about permitting medical procedures that are illegal under state law. And so the court's going to have to figure out how those two statutes work together.
All right. Well, we are waiting for those decisions. They could come as early as tomorrow. And so if they do, we'll be back with you. And Brad Jacob is Dean at Regent University, constitutional law expert. We're grateful for your time explaining these to us and helping us get a little bit better understanding on these Supreme Court decisions. Thanks for your time today, Brad.
It's always a pleasure, Dan.
All right, and everybody watching, thanks so much for being here. Appreciate it. Make sure you're going on over to cbnnews.com for more news from a Christian perspective, and checking out the CBN News Channel for our 24/7 programming. All right, God bless. We'll see you next time.